Today, we're here to review the suing case between the defendant Ryder, who'll be joined by his lawyer Allobes, who'll be suing the plaintiff, Mayor, who will be joined by their lawyer SoulsnatcherOR, for the reason as follows. Police brutality. Would the defendant like to share their part of this case?
Yes. Your Honour, may I please approach the bench to make a statement?
Yes, you may.
Thank you. Am I running? Okay. Your Honour, in the time of date, my client was... Hold on, sorry, 1 second. My client states the following. Hello, my name is Maya, and my statement would only be that the only thing I can remember is the judge telling him to leave and then he wouldn't, so I had to chase him. Because this is not a part of the actual statement here. Maya was the on-duty officer a part of this court case. Just for the record. There isn't much to remember because my memory isn't that good, but the judge told me to get him. He went into circles, and I was trying to get away, and I stopped him. Just want to say that I'm sorry for hurting you. It was an honest mistake and it won't happen again. Now, Your Honour, we do have a preposition for the plaintiff's side over here. Mayor themselves, as a police officer, would like to use their money to pay for any medical bills, if that was possible.
Yes, they can pay for any medical bills.
Perfect. Your Honour, that is currently all for the moment.
Would the plaintiff like to share their part of this case?
Yeah, sure, Your Honor. Hello, my name is SoulsnatcherOR, and I'll be the representative for Mr. Ryder for today. Unfortunately, Mr. Ryder could not attend today's court case due to unreasonable reasoning. But today, I will be explaining the definition of excessive force. Sorry, give me a sec. Excessive force is a type of police brutality that refers to use of force beyond a reasonable police officer used by the question or appealed upper hand a person. Officers should use the minimum amount of force necessary safety contained situations. As you see in the image, Mr. Ryder is pinned to the ground by tackles, which is a good case. But afterwards, it is shown that Mr. Maya is beating him up, showing that it is an excessive force instead of just tackling him randomly.
Objection. Your Honour, my client was in the state of fidgeting where the plaintiff's client over here was fighting back.
May we see this image?
Do you have any?
Your Honour, do you have the current proof of the case?
Yeah, I see it now.
Okay.
Objection, Your Honor. Is there any evidence showing Mr. Ryder resisting arrest?
Objection.
No,
Because the
image.
Actually, no, never mind. Forget that objection. I forgot what I was going to say.
Your Honor,
also to add to my case,
Actually, hold on. Objection. My client would like to make a statement real quickly.
go ahead.
just Your Honor, I would like to say, I don't have any definitive proof for it happening, but in one of the cases that he was at, which was the one that we're at that you're stating, he told me to go around the corner to talk to him around where that door is, and he pulled a gun on me and told me to get him into the car.
Do you have any evidence of him holding the gun?
Currently, we
No,
do
I
not
don't.
because QPS would not let us access the body cam footage.
Did you tell Mr. Ryder several verbal commands before asking him or before tackling him to the ground?
Yes, I told him multiple times to please stop talking at the back, and the judge himself told me to go get him.
At any point, did Mr. Ryder shoot the gun?
No, he didn't, but he was threatening.
Objection. Although the gun was pulled and it was not shooting, it still counts as threats while holding a firearm. It could present a danger to a police officer. The police officer has every right to engage with the suspect, which this means tackling. If the suspect is fighting back, then they can also use excessive force, or not excessive force, but to hold the suspect down.
Objection, Your Honor. The level of force is sorry. I think I'm going to be saying this wrong. Assaultive, which a subject is a non-lethal potential lethal weapon that against someone or an officer. This ensures non-lethal weapons such as a taser, baton, pepper spray, or breech gun could be used. You could
Objection.
use Mr. Reiner. I mean, Mrs. Maya. Sorry, my bad. Mrs. Maya should have used her taser or some sort of other.
Your Honor.
To be please wait a moment. To be fair, if the defendant is holding a weapon that is lethal, I don't believe that the plaintiff should be holding a non-lethal weapon. It should also be a lethal weapon.
Your Honor.
And I
At that
believe he's
time,
just
I was
back up.
holding a taser. No gun was on me.
On your body,
No.
did you have a weapon, such as a gun?
I did not have a gun. All I had was my taser, pepper spray, and my baton.
But you
Okay,
already had
and
to the
as you
ground. Am I
stated,
correct?
you couldn't access a body cam footage at all.
Negative, Your Honor, we could not.
Okay, the
Sorry,
plaintiff
guys. I
may
got you.
continue.
So as you see on the image, Mr. Reiner was already on the ground, not fidgeting because he was already been tackled and pinned to the ground. But still yet, Miss Maya still keep repeatedly beating him up, showing that this is excessive force.
Objection. There is only one photo logged into evidence of this case. My client has marks on their body of fighting back. They have 3 scratches on the left and right arm. One on the left arm is
But he
across
like
the arm
sorry,
vein.
Your Honor. Objection, Your Honor.
Yes.
My client has repeatedly tried to attack. Is it at this point of the confrontation? Of course, my client would try to break free from this tackle, but unfortunately,
Objection.
but
Objection.
on
That's
also
literally
on
admitting to
sorry.
fighting back. That's literally admitting to fighting back. That
Yes,
gives my
admitting to
client
fighting,
every right to hold them
admitting
down.
to fight back, admitting to fight him back, but he was already on the ground already.
Yes, but
At
you
first,
just
they
said
was
that your
trying to fight,
client
but
was trying
he
to get out
tackled
of it.
him, but
You
didn't have
literally
the
just
chance
said
to
your
fight
client was
back.
trying to get out of it,
He
mate.
didn't have the chance to fight back when he was tackled. He tried to. You guys try to. Okay, wait, my bad. I'm trying to load in. Quite busy.
Your Honor. He verbally assaulted me. I was trying to just get him down into the ground because of what he was doing.
Do you have any other proof or witnesses of this?
I do not have any proof or any witnesses. As the body cam.
Please
He was also
remind the
trying to run
jury.
away. Sorry, my bad.
Are we able to request any camera footage from the courthouse? Would the courthouse contain any camera footage that you guys could have accessed?
Your Honor, we have just gathered evidence from the judge in time, and I will send you the proof in a minute. It was gathered by the CCTV footage from the courtroom and authorized by the judge, Jordan, to prove liable evidence. So during this time, it was outside the courthouse, like my client stated. The images will be sent to you in 1 second. You need to find your messages.
Hmm.
Your Honor, are you okay with that proof?
Okay, so I have seen that the judge confirm
But I
that they have gathered the CCTV. Does it show anything proving the point of mail?
Yes, it does, Your
Proving the
Honor.
point of the
My
plaintiff?
my client proceeded multiple times with verbal warnings. The plaintiff's client proceeded to not listen, pulled a gun, as my client also stated. My client tackled the plaintiff's client down to the ground and proceeded, and the plaintiff's client proceeded to fight back. So my client hit them in the gut, and they still proceeded to fight back.
Okay.
as you objection, Your Honor, as you also can see that my client was also trying to run away from this beating, as you state in the image that was my car.
Objection, can you please repeat that, but actually elaborate? Because nobody said anything about a car. Actually, no, never mind, I do remember about the car. Sorry.
It was stated by the defendant when they
Yes.
were
Oh no.
tackled to the ground that that is their car.
Yes, I do remember that.
Excuse me, can someone load me out of my car, please?
What? Lionel.
Again.
This would be my conclusion. Or sorry, my equity. Oh, there you go. Thank you very much. That is all, Your Honor.
Thank you. Does the defendant have anything else they would like to? Oh wait, sorry.
Currently
Does
at
the
this
plaintiff
time,
have
Your Honor.
anything?
Currently at this time, Your Honor, no, but I would still like to remind the court, if this does end up going the wrong way, my client would politely like to pay the medical bills that arise.
Thank you. Can all thank you for your input. Can all not injury? Oh my god. Can all juries please make their way to the consulting room? Okay, me and my people have spoken, and we have came up, and we have decided.
Actually, Native, forget that last message.
We have me and the juries have spoken, and it has been decided that the case against the defendant will now the defendant receiving 2 years in jail time for police brutality and assault, and it will have to pay 50,000 in compensation for medical bills to Ryder. This outcome comes as the proof given doesn't prove in anyone in any person's favour, as
Your Honor, did you forget about the judge providing the CCTV footage?
the CCTV footage doesn't prove that Mayer is in self-defense.
The
It
plaintiff's
pro-
client literally fighted back.
The plaintiff,
Yeah, the plaintiff's client literally fighted back.
but the thing is, the plaintiff is Ryder.
Exactly.
Ryder was because he was being arrested. If he was pinned down, he would have been detained.
He was pinned down and he was fighting back. My client
So,
literally.
he was meant to be going to jail.
So may I ask why then, if they were pinned, why they weren't handcuffed? Instead, they were non-lethal.
Your Honor, they were still
pulled out
resisting at
and
the
they then-
time. Your Honor, they were
and
still
then-
resisting at the time.
Also, isn't it all officers are supposed to be prepared before on patrol? Why didn't she have all her equipment beforehand? She's an on-duty cop. She had a uniform on.
May I ask why there was?
You're telling me
why you
you're
didn't request assistance? If there was something happening, why you didn't request assistance from another member of the security team?
Because there was no one else. It was just me, Your Honor.
So there was no other member of the security team that could assist you?
No,
If
Your
you
Honor.
would like me to
It was just
confirm
me
that,
and
I
him.
can go confirm with the judge again.
No, thank you. That
And
won't be
also,
necessary.
Your Honor,
You may speak.
Judge Jordan told me to take him out and sort him out.
which you did, but you put excessive force into it. You didn't need to beat him up even though he was already tackled to the ground.
Attack me. He was attacking me.
As a QPS officer, right? Are you always prepared on duty?
He was attacking me.
You should be prepared. You should at least have a non-lethal purpose. You also been trained with this. Of course, you attack with him, right? You should be already pinned to the ground.
Excuse me.
Your Honor, I'd please like the plaintiff to stop interacting with my client for the meantime.
Okay.
I'd like to say one thing. I was prepared. I had everything on me that I needed.
Also, Your Honor,
may we ask?
Actually, no, scratch that more.
May we ask why we were given proof showing that you tackled the plaintiff and then proceeded to beat them up?
Your Honor, I tackled him because I didn't have time to get out my taser. I was right in front of him. It was really fast.
I understand why you tackled him, but then why did you proceed to beat them up? You have things to stop that.
Because he tried to get away.
Your Honor, the position my client was in.
Something.
Your Honor, the position my client was in, they were not able to access their taser and/or their pepper spray or their baton.
May I ask how they weren't able to?
He kept kicking me and scratching me. I couldn't do anything. I was attacked.
Your Honor, let me picture a scenario for you real quick. If you were an on-duty cop and you just tackled someone and they kept on pushing fingers at you, how do you think you're going to access the firearm or a taser?
Argumentative. That's kind of a bit of argumentative, buddy.
Okay, so I see what you are trying to say, but it still doesn't. Still shows them beating them up. They could have stepped back from that incident and pulled a weapon instead of assaulting and beating up.
Excuse me,
That
Your
person.
Honor.
Your Honor, no offense, but can I just state once again, my client was in the wrong position to push back. The plaintiff's client was, what's the word? I'll just say pushing for now. My client kept on, my client kept on getting pushed by the plaintiff's client multiple times. My client was not able to access any type of firearm or non-lethal weapon at the time.
Okay, I have now also been provided with additional proof saying that there was another security unit available. Why weren't they contacted? There was another member of security in the room, and you never tried to contact them for assistance, never tried to reach out in any way. May I ask why?
Well, Your Honor, at that time I was outside. I didn't know that there was another person in.
There was another person with you throughout the entire case.
I didn't know they were there because most of the time I was outside of that door. I wasn't inside.
May I please mention for the court, the other security guard that was on this scene, might I add, interrupted a court case while playing social media and or playing a video game during a court case. So I'm pretty sure it wouldn't have mattered anyways if they got
Argumentative.
distracted.
It's argumentative. That's a different subject, buddy.
It's not. It's
Just
stating the fact that the other
argumentative. It
security guard was
is.
not doing their job
Because you're
properly.
saying something different now.
It's not saying
That
something
happened
different.
afterward.
It's stating a topic related to this court case.
That thing happened right
It's still related,
afterwards.
mate. It's still related. What do you want about? It's still related.
Judge, can I
The
have
other
a
security
bench?
guard
Can I have a
wouldn't have
bench?
listened anyways.
Can we have a
Can you stop? If the person,
Can we have a bench, please?
if the please hold, if the if the defendant was outside and the plaintiff was contacted, the additional security guard was contacted to assist, then why? Then they would have heard heard it. Just because they were supposedly playing a video game or watching something doesn't mean they concentrated on their duties. They can still hear a radio, especially if the radio is strapped right next to their ears on the side of their shoulders. How wouldn't they hear that? They would hear if there was a panic button. They would hear if they needed assistance.
Your Honor, here in Australia,
May
we
I
don't use
request
panic
a bench,
buttons.
please? Okay, may I request a bench time, please? Just between me and the defendant's lawyers, and with the judge. May I request a
Okay,
bench?
there will be a 5-minute bench.
Which VC do you guys want to head to? Consulting VC.
Yeah.
Okay.
Okay. Can the defendant please explain their part of the story?
To the jury and to the defendants and to the judge, just to recap what happened in that recess. We went over the topics of why my client did not push back and why my client kept on fighting back. The reasons were as following. My client could not push back as they kept on being held. My client tried multiple times to push back. It did not work. We also went over miscommunications and how my client could not communicate with the other security officer due to it could be a fault in the training of the security officer, aka my client, or it could be just thoughts going through my client's head and tricking them. Now, might I add, this happens to online AFP officers and QPS. It's quite normal in the body as it's fast reaction times and it's like an adrenaline rush. It just hits you all at once and you go through a spiral. Your Honor, that's currently all I have for the moment.
Would the plaintiff like to explain their part of the story?
So at this moment, what we talk about is about sorry, about the defendant being up Mr. Reiner, my client, repeatedly and trying to explain why was she not try to back up, even though that he wanted to try what call it, he tried to escape from her grip. At that point, okay, at that point, after backing up, she shouldn't have either put out a tool or a time to reassess of her situations that all police officers have to do at those times. It's really common, like Mr. Allobes said, that a lot of adrenaline hits, but also a lot of officers are trained to reassess what's their situation, to keep calm in their situations. And so that's what basically we talked about, and yeah, I have nothing to further say.
We appreciate both parts of your stories once again, and we apologize to do this again. But can
Your Honor,
all
may I please quickly state one thing quickly before you go off to the jury?
you have 30 seconds to explain this?
Okay, my client would like to do the following. Pay all hospital bills for the next 4 years. So that would add up to like almost 4,000 depending on what happens. And they would also like to pay 10,000 in damages.
Okay, thank you. Can we now get all consultants and juries to please join the consulting room? Apologise for the wait once again.
No
The
problem.
jury has spoken. It has been decided that the case against the defendant will result in Mayo receiving 8 months of community service, retraining, and owing $50,000 in compensation to Ryder to pay medical bills. Is that this comes after we have seen in CCTV and given no additional proof provided to the fact, and and has been decided by both by all of the consultants that the information given could have been evolved. Is there any member that would like to add to this statement?
None whatsoever, Your Honor. Thank you.
Nothing for me too, Your Honor.
Thank you to the oh my God. Thank you. We appreciate everyone for coming today. This court case is now concluded. What's that?